Resume recording. I'm going to start the live stream now in 3, 2, 1. So there's a problem with that too. Sorry. Hello, everybody, and welcome to this webinar on intersectionality and marginalized women's access to justice. My name is Melissa Lamina, and I'm the Legal and Communications Associate Officer for the International Commission of Jurists Africa team. I am joined today by my Regional Director, Kajal Ramjathan-Keo, who will be chairing what I think will be a very informative and insightful conversation. So as we all know, the 16 Days of Activism Against Gender-Based Violence is an annual international campaign that begins on the 25th of November. That is the International Day for the Elimination of Violence Against Women, and runs until 10 December, which is Human Rights Day. And since its inception, this campaign has been used as an organizing strategy by individuals and organizations across the world to call for the prevention and elimination of violence against women and girls. While the scourge of gender-based violence affects women and girls everywhere, there are certain women who may be subjected to increased levels of violence or struggle to access legal and support services or to assert their human rights because of their age, their race, disability, ethnicity, sexual orientation, or other status. Today, we are joined by 4 incredible human rights advocates who will be sharing their experiences and insights on access to justice, and in particular, the impact of intersecting forms of discrimination on marginalized women's access to justice, the challenges obstructing women's access to justice, and the possible avenues for ensuring a more inclusive and equitable legal system in general. I'll give the panelists an opportunity to introduce themselves, but first I'd just like to do a bit of housekeeping. Please note that we are recording this meeting as well as streaming it to our ICJ Africa Facebook page. Kindly ensure that all of your microphones are also muted throughout the conversation as to not interfere with the speakers when they are speaking. You will all be given an opportunity to ask questions later on, but feel free for now to introduce yourselves to us and to fellow participants using the chat feature. But at some point in time, I will open the floor up for a Q&A session after the panelists have made their interventions. So with that being said, I'll now hand over to the panelists to do a brief round of introductions. I think we can start with Kajal, and then we can move on to Melissa and continue from there.
Thank you very much, Melissa. Greetings to everybody. Good morning, good afternoon, good day. Greeting you wherever in the world you are joining us from. My name's Kajal. I'm ICJ's Director of the Africa Program. Very happy to be joining you today to commemorate the 16 Days of Activism and to give a brief overview. Well, actually, I won't do the overview just yet. I'll do it after the introduction. So I'll hand over to Melissa.
Thank you so much, Kajal and Melissa, and good morning, good afternoon, good evening, everyone. Greetings. I am Melissa Upreti, the Regional Director for Asia and the Pacific at the ICJ. I too am absolutely delighted to be here today with all of you and my fellow panelists to commemorate 16 Days of Activism. Back to you, Kajal.
If we can do Nala, Aruna, and then Zione. Nala, you're still muted.
Okay, I'm sorry about that. I thought we should mute when we're not speaking, and it's not easy to get back quickly to the sound. So good afternoon, good morning to all of you, wherever you are. It's really a privilege to be associated with yet another activity of the ICJ. I'm Nahla Haidar. I'm member of the CEDAW committee, and I have had the privilege to work with Kajal in her capacity as regional director, but also with Melissa Upreti in her former capacity as member of the working group on women in law and practice, and as well with my colleague, who was my dear colleague in the Bureau of CEDAW, Commissioner Aruna Narayan. I have not had the chance to meet Siona before, but I heard a lot about her work, so I'm really very happy to be with her on this panel. And I look forward to a fruitful discussion, not only in the context of the 16 days, that is a very important campaign, but in the context of all what is happening in our world today and where women are paying the highest bill, as usual. So thank you again.
So yeah, probably I'm next. So I'm, of course, I'm also delighted to form part of this panel with all my distinguished co-panelists. My name is Aruna Narayan, and I'm a new ICJ commissioner, maybe the newest, I don't know. And this is one of my first ICJ events, about which I'm very excited. I'm a judge of the Supreme Court of Mauritius since 2015. And I hasten to say that quite obviously, whatever I'll say today will be expressing my own personal views, and nothing that I say today will bind the Supreme Court of Mauritius, nor any judge of the Supreme Court of Mauritius. And as you've just heard from Nahla, I'm also a former member of the CEDAW committee, a former rapporteur, and a member from 2017 to 2022. So I speak mostly in that capacity as former member of the CEDAW committee, and I'm very pleased to find on this panel my good friend and mentor on CEDAW committee, Commissioner Nahla, but also in the audience, another mentor of mine, Patricia Schulz. So I'm really looking forward to this discussion. Thank you.
Apologies, can you hear me? There's works going behind me, which is just going crazy. My name is Onenta, and I'm a judge of the High Court based in Zomba, which is the Eastern Judicial Region of Malawi. Currently not in the warm heart of Africa. I wish I was in the warm heart of Africa. I'm cold somewhere else, but I am looking forward to the discussion today and interacting with everybody on this webinar. Thank you.
Thanks very much to all of you. So we are delighted to have such an eminent panel with wonderful expertise that they will share with us today during the deliberations. To give a very short opening, the ICJ has been promoting women's access to justice, women's rights, and women's participation in various platforms. The work that we have been doing in promoting, in particular, the Bangkok General Guidance for Judging with a Gender Perspective in South Asia and Southeast Asia has been of particular significance in our work. We hope to be able to continue this work in Asia and to extend it to Africa, particularly with introducing the Bangkok General Guidance to judges in Africa. We have 4 presenters who you've met already, some who have worked very closely with ICJ's Women's Access to Justice project. And so I'll start with Melissa Upreti. Melissa is a new director to the ICJ. We're delighted that she's leading, heading the Asia program. And I also want to extend a warm welcome to Melissa. So to start off with some questions for Melissa, the first question, in the Asia and in the Pacific region, what are the common legal barriers that hinder women from accessing justice? And what are the ways of dismantling these barriers and promoting a more inclusive and effective legal system?
Thank you so much, Kajal, for that warm welcome. So with regards to the most common legal barriers, which I'm sure everyone is quite familiar with, given that everyone is working in this field, let me highlight a few just to kind of kick off the discussion. And then I'm sure my fellow panelists will build and expand on these barriers and also get into some of the nuances, because what I'm going to say in several minutes is really just the tip of the iceberg, and intended to just provide a basis for a more in-depth analysis. So basically, strengthening women's access to justice, especially those who have experienced violence, is an important focus of the International Commission of Jurists' efforts to advance the rule of law. So that's the broad framework, really, for the organization's work. And some of the most common barriers that we have identified include things like harmful gender stereotyping and gender bias. These are grounded in sexism and misogyny, and such beliefs and attitudes transcend all cultures, as well as political and legal systems, even our economic and broader social systems as well. Now, the common notion that women who do not comply with these inherently discriminatory stereotypical norms and sociocultural expectations, the notion that they are transgressors is also a barrier because it helps justify the denial of redress as if women do not deserve it in the first place. Now, harmful stereotypes and gender bias reflect in how women are treated by a range of judicial actors and law enforcement agents from the very beginning of an investigative and prosecutorial process until its very end when a final decision is made. We know that it's common for women's complaints to just not be taken seriously at all. Now, in addition to this, there are widespread gaps in legal literacy. Women are often not aware of their rights and do not have access to information about them. And without this precondition being met, the quest for justice really does become impossible. In many jurisdictions, women do not have the legal protections and rights that are needed to pursue legal redress, which often stems from discriminatory laws. So in fact, discrimination is often codified in law. So for example, by not adequately recognizing their legal capacity, for example, persons with disabilities, by not providing equal or any legal protection, for instance, informal women workers, especially if they are migrants. Family laws impact women most profoundly and are almost universally discriminatory or have some discriminatory provisions. In many countries, women are not granted equal rights to nationality and citizenship, which effectively makes them second-class citizens and limits their ability to access justice. In others, unreasonable evidentiary requirements, such as those that make it necessary to produce additional witnesses to prove that a crime was committed against a woman, can also serve as a barrier and make it almost impossible to obtain justice. Now, another common barrier that prevents women from accessing justice is also the criminalization of certain behaviors that disproportionately affect women. Contrary to general principles of criminal law, which require a presumption of innocence until proven guilty, when it comes to certain crimes involving women, there's a presumption of guilt. A leading example of this is really in cases involving abortion, where it's criminalized. It makes those who have experienced gender-based violence and subsequently sought abortion fearful of seeking redress for the original crime of violence that was committed against them. So in practice, due to the combination of discriminatory laws and attitudes, there are many blind spots in the law when it comes to women's access to justice. Procedural negligence and lapses abound, making violations of due process commonplace. And this happens with impunity, which also deters many from pursuing legal redress. There's also an opportunity cost for seeking legal redress, which, for instance, women in paid employment face in the absence of paid time off from work, specifically to pursue a legal matter. Many cannot prioritize the pursuit of legal redress because of their burden of care responsibilities and lack of family support. So aside from the legal barriers, there are all these other barriers that are also related that cumulatively then make it almost impossible for women to pursue avenues of redress. Of course, the poor technical capacity of duty bearers, unavailability of quality support services, including legal aid, health services and shelters, combined with the lack of coordination among government agencies, are also common barriers that are more broadly sort of systemic and structural as well. Legal aid, where available, can be of poor quality, and legal processes can be unaffordable on account of various fees and hidden incidental costs for things like transportation and childcare. The absence of specialized services for certain populations who face additional barriers, such as women with disabilities, and this is just one example, there are so many subgroups of women who face additional barriers, women in high-risk situations, including adolescent girls, and those without a dwelling of their own. All of these different situations and circumstances can create barriers and inhibit many from seeking legal redress. So I just want to highlight one more barrier, which I think is important to mention, which is perhaps generally sort of overlooked in conversations, but really important. I'm speaking about the judicial system and the legal profession in general. One overlooked barrier is really the pervasive occurrence of gender-based discrimination and violence in the world of work. It is crucial to ask, how can a legal system with relatively fewer women in positions of influence, and where female jurists, lawyers, judges, prosecutors routinely and disproportionately experience discrimination and violence in various forms and harassment, how can they really help provide access to justice to other women when they are in this kind of situation themselves? Data reveal that the level of misogynistic harassment and bullying experienced by women in the legal profession is much higher in comparison to their male counterparts, and this is a global problem. For those belonging to racial and ethnic minorities, the situation is even worse. And then, of course, in terms of challenges, I'll just add one more. There are new things like online gender-based violence. Our legal systems are not adequately equipped to respond to online gender-based violence. Meanwhile, women experience high rates of abuse, both personal and professional, in online spaces. On the one hand, legal frameworks are falling short of protecting individuals against abuse. And on the other, there is a vast amount of overreach by state actors, as well as abuse arising from the targeted use of laws supposedly designed to protect digital rights, and women human rights defenders advocating for justice face this kind of targeted abuse at the hands of state actors. So regarding the ways in which we can dismantle some of these barriers, it is extremely challenging. Many judicial actors see it as their role to simply apply the law as it is, rather than to question its purpose and impact. When it comes to issues that impact women, the premise for discrimination can be ideological, as well as cultural and embodied in the law itself, which makes it seem normal and acceptable. Of course, there are some really good judicial actors too. So I'm not, dismissing the work of those who are contributing to addressing some of these issues. But sadly, generally speaking, there are these problems that persist. So despite the challenges, however, there are certain steps that can be taken, and I'll just flag a few again with the idea of kicking off our discussion. Some of the things that come to mind include legal reform. Legal reform aimed at recentering laws to make them non-discriminatory and gender responsive through a participatory process in which women are involved is really important. And taking a human rights-based approach can get us there. 2, legal awareness of rights among women is crucial through formal education as well as public awareness campaigns, and those entrusted with the duty to protect our rights and our fellow citizens must also be made aware of what these rights are and the consequences of violating them. Number 3, legal aid must be available, accessible, affordable, of good quality, and provided in a manner that is acceptable to women. Number 4, the legal architecture, including formal avenues for recourse, must be redesigned, and policies must be introduced to remove well-known barriers with the participation and input of women. And this is going to require significant financial investment. Last but not least, the legal profession itself must be made more inclusive and representative, in addition to being safe for women. So those are my responses to your question, Kajal. Back to you.
Melissa, I have one more question for you.
Mm-hmm.
In the context of Asia and the Pacific region, how can judicial officers leverage ICJ's 8 March principles, the Bangkok General Guidance, and other international human rights laws and standards to enhance the protection and promotion of the human rights of marginalized women? And could you provide a brief overview of the 8 March principles, the Bangkok General Guidance, and their significance in advancing gender justice and equality?
Sure. So since the last few years, as mentioned by you earlier, the ICJ has implemented a major initiative to enhance women's access to justice, which is the Access to Justice program. And this program has relied heavily on international law, CEDAW in particular, but also other international instruments. Also make connections to the SDGs, because that is something that is, the timeline for that. The deadline is coming up quite soon, and it's very relevant to this whole conversation around how to ensure and protect and advance legal rights. And of course, national legal frameworks and constitutional protections are also part of this mix, looking at whether states are actually fulfilling the promises that they have made with regards to fundamental rights, in addition to their international obligations. So drawing from all of these, as well as the practical experiences of a range of judicial actors, judges and lawyers and legal advocates working in this field, but actually in particular judges, this initiative led to the creation of the Bangkok General Guidance, which I'll refer to the guidance. It was developed by judges in the Asia Pacific region with the input of civil society to tackle barriers to access to justice in many different types, and at many different levels. This guidance sets out important considerations for a range of actors within the judiciary and beyond in applying a gender perspective in the administration of justice. So the first edition of this guidance was developed through a process of judicial dialogue hosted by the ICJ, in which judges from Indonesia, the Philippines, Thailand, and Timor-Leste participated in 2016. In 2022, judges from 6 countries in South Asia adapted the guidance to the South Asian context and formulated an updated version for judiciaries in the region. Now, the guidance urges judges to ensure unhindered access to justice for women by applying the principle of equality and non-discrimination, and by identifying, addressing, and eliminating gender discriminatory practices. It alerts actors from different types of justice systems, formal and informal, and at all levels, to the fact that harmful gender stereotypes and gender biases, which may seem quite normal, actually promote inequality and perpetuate discrimination, thereby undermining access to justice for all. The guidance also makes recommendations to courts with respect to the types of institutional policies that they should adopt to help them become more gender sensitive and gender responsive. And the guidance was developed with the direct input of judges in the region, including a notable number of female judges, which really helps explain its gender sensitive character, and I think gives it legitimacy as a guiding tool. It draws from international law, specifically CEDAW and other relevant international instruments, including recommendations issued by the Special Rapporteur on the Independence of Judges and Lawyers and concluding observations of the CEDAW Committee. It also draws on comparative law and good practice. Now, judiciaries in 6 countries in Asia have already committed to adopting the guidance in their training programs and in the adjudication of cases. And countries like Indonesia, the Philippines, Maldives, and Nepal are some of the countries that are leading on this front. Another very important tool produced under, I would say, the leadership of the ICJ, but in collaboration with jurists from around the world, including from Asia and Africa and other regions, which I'd like to highlight, is the 8 March Principles. The title is a bit long. It's the 8 March Principles for a Human Rights-Based Approach to Criminal Law, Proscribing Conduct Associated with Sex, Reproduction, Drug Use, HIV, Homelessness, and Poverty, which were developed with the input of jurists. And this is a tool for assessing whether criminal provisions in national law are consistent with general principles of criminal law and international human rights law. And the principles are being utilized in many ways. And some examples include, as a key point of reference at a judicial dialogue with judges and human rights activists from several countries in the African continent and South Asia, at an event entitled Decolonizing Jurisprudence, Protecting the Rights of Dignity, Privacy, Equality, and Non-Discrimination of Marginalized People in Post-Colonial States. At this event, which I think the title is really interesting, and I wanted to mention this explicitly because it also gives a sense of the different entry points and connections that can be made, right, through the use of these principles and what we're seeking to address. The participants at this event were introduced to the principles, which they have actually pledged to use in their future work. So we're hopeful that we can expect to see conversations around legal reform, as well as questioning the premise of many of the laws and the legal provisions that govern our lives, which is also, I think, a necessary part of what we need to do. These principles were also used to shape a discussion at a regional workshop in Latin America, again, with judicial actors and activists from across the Americas, with a focus on access to justice for persons with disabilities, with the idea of developing a common advocacy agenda to enhance access to justice for persons with disabilities, which involves ensuring state compliance with human rights law in its substantive criminal laws. Again, it's another example, a different type of example that shows how these principles are being used. And earlier this year, just to provide another example, the Supreme Court of Nepal reduced prison sentences of 2 adolescent defendants convicted of infanticide based on actually specifically Principle 14 of the 8th March Principles, which relates to sexual and reproductive health and rights. And then finally, another useful tool for addressing barriers to access to justice, which can be used by a range of judicial actors, includes a checklist, an online gender-based violence checklist that has been produced by the ICJ. It aims to assist states to draft new laws or amend existing ones to prevent and address online gender-based violence against women in line with their legal obligations under international human rights law and standards. It provides a clear and accessible set of guidance for states on what these laws should aim to effectively prevent and address. And it addresses key issues of definitions and guiding principles, the prosecution of and punishment of perpetrators for online gender-based violence, legal protection and reparations for victims and survivors, procedural rules relating to online gender-based violence, and gender-sensitive implementation of these laws. So it's very holistic in its approach, and one more tool that can be utilized. So with that, I'll just end my intervention and give the floor back to you, Kajal. Thank you.
Thank you. Thank you so much, Melissa. Thank you in particular for that overview of the 8 March Principles and the Bank of General Guidance. We really appreciate that. So we will move on to Nala Haider. Nala is an ICJ commissioner and member of the CEDAW committee. So Nala, in addressing the intersectionality of discrimination, particularly affecting marginalized women, such as sex workers, LGBTQI women, women seeking abortion care services, women with disabilities, and women living in poverty, how can the CEDAW committee advocate for legal frameworks that effectively dismantle barriers and ensure equal access to justice for these diverse groups of women?
Thank you. Thank you very much, Kajal. And I think the diagnosis and many of the things that Melissa said, they really set the larger tone. What I'm going to focus on is obviously that the practice of the committee, we have seen how much women and marginalized groups of women in particular are disadvantaged in the justice system, because as we were already hearing, they often face unique social and institutional barriers to accessing justice, bias in justice institutions, social stigma, psychological trauma of bringing claims, and lack of gender-sensitive procedures. And I wanted here, just before I continue, to open a bracket to say that I think one very important tool that was not cited so far in our discussion and is a very important one is General Recommendation number 33 of the committee, which was in 2015. That means a little bit before the initiative of the Bangkok guidelines, and that has informed the Bangkok guidance note. And I think we need to do much more to make this GR more understood and useful for state parties, because the purpose of the GR is providing guidance, and sometimes when we come back to dialogue, we feel like nothing was registered from this guidance because we are in the same negative posture. So the CEDAW committee has consistently advocated for appropriate legal frameworks to tackle intersectional discrimination. And it has always engaged member states to recognize and address the unique challenges faced by marginalized women. This involves promoting inclusive policies, fostering awareness, urging the adoption of laws, but laws alone cannot make it. We really have to address the multifaceted needs in this area, and in particular on women in their diversity. So here, the work of CEDAW with civil society organization is key for promoting the intersectional perspective within the legal reforms, and it can contribute and has contributed to dismantling some of these barriers that Melissa was alluding to and ensuring equal access to justice. We know, and it's no need to reiterate, but it's still important to repeat, how much discrimination against women is based on gender stereotypes, stigma, harmful patriarchal norms, gender-based violence, as also was mentioned, the fact that they don't adhere to what is called the norm. The stigma is so heavy, and this has an adverse impact on the ability of women to gain the access on an equal basis with men. And the discrimination was against women, when it is compounded by intersecting factors, can vary from grounds of ethnicity, race, indigenous, minority status, political, etc., name it, sexual orientation. Obviously, the issues of lesbian, bisexual, and transgender women or intersex person are at the heart, and more so the issue of sexual orientation and gender identity. And these intersecting factors make it very difficult for these women, as was already testified, to access justice, and make it even more difficult because of their illiteracy, as was mentioned, because of their status, that they are often trafficked women also in that context. In the context of armed conflict, I was just saying that at the very beginning, that we are doing this event also in a larger international context that is really so concerning. And so we see that women also who are asylum seeker, who are internally displaced, who are stateless, who are in the migration. So we cannot, the list does not end. In fact, in CEDAW, we always struggled, and Patricia is here to say whether we go for listing or we don't go for listing. It's so difficult to really be inclusive of all the aspects of intersectionality. The committee views and recommendations concerning the steps that need to be taken to overcome obstacles encountered by women in gaining access to justice. They are informed by the experience in considering the reports of the state party, the analysis of individual communications and the jurisprudence, and the conduct of inquiries under the optional protocol to the convention. And some of the key approaches that the committee is able to advance are definitely the inclusive policies, to develop and implement these policies in order to address explicitly intersectionality, considering the diverse experience of women based on the factors that we just mentioned of race, ethnicity, sexual orientation, disability, just to name a few, and socioeconomic status. It also speaks definitely, as was also mentioned, about the necessity of legal reforms and the possibility to achieve them, to advocate for and enact laws that explicitly prohibit discrimination based on multiple grounds. And this includes updating existing legislation to ensure it encompasses intersectional perspectives. And the education and awareness cannot be emphasized enough, and equipping women also with the knowledge, as was said earlier again, and data collection, which is capital if we were to improve also the methods to capture this data, to analyze the information on the intersecting identity. It is crucial for identifying patterns of discrimination and tailoring effective interventions. Capacity building as well, providing training for professionals in various sectors. We spoke about the legal profession, but not only. We know, of course, the importance of the law enforcement, the healthcare, the education, etc., etc. Empowering marginalized communities, but through support programs that empower women marginalized economically, socially, and politically, and creating opportunities for leadership and participation in decision-making process. Collaboration with civil society that focuses on intersectional issues. Collaboration can amplify efforts, share resources, and ensure a more comprehensive and nuanced approach to addressing discrimination. Obviously, legal assistance, it goes without saying, and it is very well detailed in our GR 33, how to ensure the legal assistance for women facing intersectional discrimination. Then, of course, international cooperation, fostering international cooperation to address cross-border issues related to intersectional discrimination and sharing best practices. And last but not least, I think media representation. I would like to conclude on your first question by saying that really combating intersectional discrimination for the committee has shown how much it requires a multifaceted and collaborative approach that involves government, civil society, and the broader community, with a particular emphasis on protecting the civic space and ensuring that human rights defenders and organizations are no longer targeted because of their work, and that their own right to access to justice is also protected. Thank you.
Thank you. Thank you for that, Nala. And to move on to a second question for Nala, recognizing the evolving landscape of human rights concerns, including emerging issues like climate change and digital rights, how can the CEDAW committee proactively integrate its efforts to safeguard and advance the rights of women in the face of these challenges? What specific strategies can be employed to address the gender-specific impacts of these global issues and ensure the protection and empowerment of women in a rapidly changing world?
Yes, thank you, Kajal. I know you're touching on a subject that is also close to my heart, as you know, and again here, I would like to refer us to a very important other tool that the CEDAW committee developed. Again, as you know, our general recommendation have been our tool to address emerging issues, to address also the gray zone area of interpretation for member states. So following several very important GR that I was able to witness personally, from GR 30 on women in conflict to now GR 40, which we're working on women in decision-making and political participation. I have been also privileged to work in particular on GR 37, which is on disaster risk reduction in the context of climate change. And we were definitely the first treaty body had addressed, because it was already adopted back in 2017, the gender impact. So, and we know that we are learning. This is an area that is new to many. And, you know, it's interesting we're talking about that today, because it's the inauguration today of COP28, to which I was not able personally to go, but my other colleague, co-focal point on climate change, is there. She's from Uganda. She's fantastically equipped, and she will do marvels, I'm sure, to bring to the attention also of member states the gendered impact, and most importantly, in the context of the discussion on the damage and loss fund, the need for reparation, in particular for women affected by climate change, women and girls. We know that this situation of crisis, they exacerbate pre-gender inequalities, and I don't need to repeat that. I think this is very clear. But we know that these impact in particular women in poverty, indigenous women, women belonging to minority groups, women with disability, refugee women, etc. In the context of climate change, definitely also older women and rural women are among the most affected. So the fact that gender inequality by its limits women's access to resources, then it becomes even more difficult in times of crisis, whether it's a natural disaster, whether it is another phenomenon, that women don't have the same access to food, to water, to land, to credit, to energy. We know the story. So as a result, women and girls are more likely to be exposed to disaster-induced risks, but we don't want to only, and they are less able to cope because of the lack of resources, not because of their intrinsic vulnerability. This is something we in CEDAW challenge very much. Women are not weak by essence. They are weak because they have suffered from historical inequality. They were never given the same access to the table, the same access to the process of decision-making, when we know that they have a lot more than is accounted for of knowledge, including, you know, traditional knowledge, to deal better with nature and to deal better with this phenomena. So what is really important and what the GR has advised the state party to do is definitely to have inclusive policy that brings women to the table at all phases of the preparation of the planning for pre-disaster, post-disaster response, planning for adaptation and mitigation, and that we want this to be really seen in terms of Article 2 of substantive equality and non-discrimination, of participation and empowerment, Article 7, 8, and 14, and of accountability and access to justice, Article 2 and 15. And all of this comes very clearly in the general recommendation in terms of guidance for state party. We want to also women to be able to provide, to be counted for in terms of data that help us understand what works, what doesn't work, and how can we increase their ability to mitigate the impact of climate change and to be more included at all the phases, but also, and most importantly, women's access to justice, access to land, access to water, which doesn't seem to be completely linked to climate change, but is a tremendous important, because most of these women are women in the rural area who are already very much disadvantaged. And once the impact of climate change happens, then they lose their ability to produce the food for their family, and they continue, as we know, to walk miles and miles to fetch water, women and girls, which leads also to girls for being, for leaving schools, and women also for being subjected to violence. So we think also that the climate change has and disaster influence has shown us the prevalence of new and re-emerging diseases, and the susceptibility of women to diseases is heightened also as a result of inequality in access to food, to nutrition, to healthcare. So the state party should invest in climate and disaster resilient health system, including reproductive health care, and ensure that these equality accessible to men and diverse groups of women in the context of disaster, and allocate resources to the underlying determinant of health and promote women's right to informed consent. I know that we don't have much time. I'm conscious of reaching the limit of the time that was allotted to me, but I think that there are several areas that I would like to draw attention to on capacity development, on access to technology, because I didn't even have the chance to touch on the issue that you raised about the technology, and also that was raised earlier by Melissa on the issue of the cyber violence and what's happening to women. And now we have another challenge, artificial intelligence itself. And we don't have enough yet documented research, but we know there's an indication that if it does not manage with ethics and properly, it may have much more negative impact on women than one can foresee. So I would like to stop here, and maybe I'll be able to speak about extraterritorial obligation, international cooperation, resource allocation, everything for the climate change, if questions come in this direction from the audience. Thank you very much, Kajal.
Thank you. Thank you so much, Nala. We are going to move on to Judge Theone Ntaba from Malawi. Judge Ntaba, can you tell us what are some of the key considerations for judicial officers, especially in the African context, when addressing cases involving the human rights of marginalized groups? And in particular, what should be considered in cases concerning women facing intersecting forms of discrimination who have been subjected to gender-based violence?
Thank you so much. I think one of the biggest things that we look at the concept of judiciaries is everybody realizes the consideration that they need to know the law. Now, sometimes knowing the law is not enough. I think for a lot of things that go in terms of gender-based violence, is that application of that law. And especially looking into that application of the law by looking into the protections within that particular law that actually afford women or any person within the gender-based violence space to actually be protected. The furthest thing that we also have to look at when we're discussing the key considerations is the promotion of that particular those rights that a person has, because it's not enough just to protect them, because sometimes it is necessary in that particular case that comes before you is to actually promote them to the extent that the person is able to actually seek back from the system what they actually need to get. And for most times, it's the nuances of protection and promotion are not always considered because we're just looking at the law and its applications. But you realize that in gender-based violence, that people are looking for more than just the application of the law as it is strict, but they're looking for its contextual issues, its promotional issues, its integral issues of ensuring the person's humanity and dignity is maintained. And I think those are one of the fundamental key considerations that judiciaries must look at. I also look at the fact that most judiciaries must address the human rights violations. And sometimes the nuance is just, the person was sexually violated. Let's get the offender in prison. But sometimes a victim is looking for more than that. They're looking from the system counseling services. They're looking at further medical assistance. And if the judiciaries are not able to offer those through the judgments that they give by actually either telling the state or the necessary service providers to address those human rights violations, it then becomes problematic that people come into the justice system and feel like they did not get any, despite that the person was arrested and convicted and is serving time, but they're saying, look, I came out of this system still violated, still traumatized, still unable to access any services. And I think one of the key considerations that we never look at, especially when we're dealing with gender-based violence, and especially in the domestic arena, is the aspect of the economic empowerment that women need. And we realize that a lot of women will not bring in cases of gender-based violence against an intimate partner or a family member if it was incest or sexual violence against a child who's within the home, is because they're actually looking at especially for the African context, they're looking at the economic aspect. Who's going to look after them and the other children that are going to be left behind? And if courts are not able to do the proper referral, and I think that's one thing that we as judiciaries are yet to do very well, and that's the referring aspect. Recognizing what services are available, apart from the psychosocial, the medical, but also the economic resources that are available to an individual out there. And I think that needs to also be one of the fundamental things that we need to consider when addressing human violations for things that come into the court system. I think we also have to realize that we have to safeguard the person. I know we call it, whether it's re-victimization, re-traumatization. I think our judiciaries are yet to still a lot more, because we're dealing with so many people within the system, that the safeguarding issues become not as paramount and as prioritized as they need to be, nor resourced as they need to be. A lot of us do not have the capacity to actually to understand that the words we use might re-traumatize or re-victimize, or even the gestures we use during cases could do that. So having to ensure that we capacitate the individuals that are dealing with the victims within the system, or the survivors, as well as the witnesses and all those people that are coming into the system, especially for redress, but also ensuring that you capacitate the structure. So the systems, the structure, and the people need to be capacitated in order to safeguard, to avoid the re-victimization and the re-traumatization. I can't underscore the fact that the considerations of non-discrimination, equality, privacy, and all that need to be at the focal point. I think one thing we also we have to consider, especially being judiciaries, is that most times access to justice requires that it's an open space. Courts are supposed to be open. But there's so much consideration that goes towards privacy, especially in gender-based violence cases. And one of the things that everybody used to say, why do you always insist that it's not just in the criminal space that we're looking at in terms of gender-based violence, but you're also looking at the civil space? If you look at family-related cases, there's a lot more that comes through in a normal divorce case that a lot of women and a lot of men do not want to see out there, that takes away their dignity because of what was happening in the home. And sometimes it might not just be the economic violence, it could be the psychosocial violence, what that entailed. And so having to ensure that the privacy aspect is maintained, not just in the criminal space, but in the civil space, is actually very fundamental. And I would say that we also need to, as judiciaries, be very aware, aware is not the right word, responsive. And we need to be responsive to the barriers and the challenges that persons that are coming into our system, especially when it comes to intersectionality. A woman can come into the system that is a woman, a sex worker, has a child, was raped. All those parameters are things that require the courts to actually take into account. But most times we will deal with the rape aspect and forget that this woman also has another vulnerability, which is the sex space, sex worker space. And she's also, the fact that she's coming to court and she's a caregiver, all those parameters are very integral to the case that is before us. And I think we need to be very responsive as judiciaries to the gender aspects and the intersectionalities that women face and people who come into the system are facing. I think we also need to ensure that we provide agency for the people that come through. Half of the time, even just the fact of victim impact statements or the ability for the court to see the person as they are before the court is necessary. And the fact that we give them the time and the space to address us and not be, should I say, nuanced with time and context and all those things is very fundamental for cases where we're dealing with gender-based violence. And it's that intersectionality that you have to look at, that if a person is going to protect and promote their rights, not only from this current violation, but on any other violations that come through, then the ability to have that agency in court is critical. And that ability can only be given if the space itself allows for such. And I think that is one thing we also need to do. And as courts, we also have to be able to have capacity, as you asked, about the intersectionalities. Most times we box things. We say, okay, rape, defilement, child abuse, maintenance, all those things. But in the maintenance case, there would have been what we call domestic violence issues. There would also be areas where the parents are actually not seeing eye to eye. There's been times where the child also has had to deal with their own abuse from either whether the space or any other spaces, or there could also be drug-related issues coming through. And those intersectionalities need to be addressed holistically from a judiciary point of view. And so there's need for us to take a little bit more time with our gender-based violence decisions, as opposed to just dealing with, oh, I've convicted you and sentenced you. What are the ancillary orders that judges and magistrates need to make to actually ensure that all these issues are addressed? Because they do get identified within the court case, but it's most times we don't get to address them in the findings and in the judgments that we do. So I would always say we need to do that. But my final point in terms of what is the biggest key consideration is the issue of bias. I think we as judicial officers need to always check our bias, conscious or conscious and unconscious. And fundamentally, whether everybody says, oh, but we took an oath to be independent and impartial, but we do realize we're human beings. And as human beings, that we have biases, stereotypes, and biases that we deal with on a daily basis. And even when you are a human rights advocate, human rights lawyer, or even a human rights judge, trust you me, we do have biases. And those need to be always checked in any case that comes before you to ensure that you actually administer the justice that is required and you promote the human rights that are necessary for that person that is coming before you. Thank you.
Thank you for that, Judge Ntaba. My second question for you, what examples have you seen where judicial officers applied international human rights laws and standards in a manner that led to tangible improvements in the legal protections offered to women?
Okay, I would say there's a particular, I'll give examples that I've used and examples that I've seen other colleagues have used. It's just a shame that Melissa has taken my example for Nepal on March 8th, but hey, we will deal with that later. But I wanted to say, I was happy when we had a case in Malawi on corroboration, where Justice Fiona Mwale took away the collaboration rule that we had in our criminal code for women for the longest time. And I think it was fundamental that when you look at the way she analyzed it, she did use international human rights law and standards to actually say, look, we need to move away from this principle. It cannot stand in the current space that we're looking at. Constitutionally, as well as internationally, it does just not make any sense in terms of to only put one party to this much level of scrutiny and also standard that goes beyond. The issue is let the evidence be weighed as it comes through, and not that they needed to do more to just corroborate the fact that they were assaulted. So that's one case I can look at. I'm just going to give you cases from Malawi. The second case was a case that I was actually dealing with. It was a girl who was actually, by the time she was coming to me, she was 9 months pregnant, just about to give birth. And she had been convicted of theft. And it was theft of a very minor thing. It was the value of that purse was very minimal. And the reason why she stole was because she was in need. She went before the court, and the court clearly did not, yes, the decision of convicting her was correct, but the punishment was excessive. And it wasn't just excessive in terms of the value, but it was even excessive because there was some level of bias in terms of the way the punishment was being meted out. Thirdly, it was excessive because we do not have in our system, we don't have policies on how to deal with a pregnant woman in the system. And so you could have sentenced this woman to community service, you could have sentenced this woman to even a non-custodial sentence that says, look, you can come in later after you've given birth. They could have done so many other things of suspending. And so in coming up to that decision, I looked at the Bangkok rules, which is the UN measures on non-custodial sentences for women. Yeah. So that helped me to say, look, what does it say? So at that point, I confirmed the conviction and then released her for time served, but also with a warning, which was also something that was available to the magistrate in the lower court to have done. The judgment was released around 3:30. By the time I was coming to work the next day, I was told this girl had delivered her child at 9 o'clock the day before, 9 p.m. So which clearly showed our system was not capable of actually looking after this child. The second one was, it's a very interesting case. It's the HIV case that I dealt with, the breastfeeding case, which was a woman that came into the system and accidentally fed her child. In that case too, there was all issues of stigma and all those particular issues. But what I find interesting was the inability of the lower court to actually look at what is available internationally on breastfeeding in terms of transmission of HIV/AIDS. Through HIV through breast milk. And the WHO guidelines are actually there on infant feeding and HIV. And those are things that when I was looking at that particular decision, I actually took into account those particular guidelines. I also took into account that this one, when she was going in, had a child as well. So as you're saying, intersectionality. Look, she is a woman who is HIV positive, a woman, a caregiver, and at that particular point, she was being imprisoned with her child. So as I also used the Bangkok rules and said, look, we cannot keep her in prison, but also that case was just fraughted with so many irregularities, and she went. Her conviction was overturned, and she went free. But I think what I want to highlight is, yes, international human rights law and standards are available, but looking at the way the use in the judiciaries is becoming less and less, looking at the geopolitical things that are happening out there. But its fundamental use of buttressing constitutional provisions, and sometimes when even those are not available, legislation and policies becomes critical for us judiciaries to use. So I would say that there is a need for us as judiciaries to continuously use international human rights laws and standards in the decisions we make, especially in spaces where we know we don't have the policies that actually address those particular parameters, but also even the law. Despite that these are only persuasive, but they're highly persuasive to the nature that they provide almost universally recognized standards. And I think that is critical, especially when you're dealing with issues of intersectionality, because if you have things that are going to do, like the 8 March principles that will talk about all sorts of issues, whether it's sex workers, reproductive health, HIV, you need to have that context in mind when dealing with the cases that are before you. So I would say that, in a nutshell, was what I was thinking in terms of these particular parameters. Thank you, Kajal.
Thank you. Thank you so much for those responses. And over to our final presenter, who is Justice Aruna Narayan from the Mauritian Supreme Court. Judge Narayan, in the African context, and particularly in Mauritius, what challenges and pressures do judges, including Supreme Court justices, encounter when adjudicating cases related to the rights to privacy, dignity, equality, and non-discrimination of marginalized women? And how can the judiciary navigate these challenges to ensure a fair and equitable dispensation of justice while upholding the rights of marginalized women?
Thank you very much, Kajal. Of course, the problem with being the last speaker is that you feel that everybody said pretty much what you wanted to talk about. And I'm very grateful to my co-panelists, Melissa for setting out the legal barriers, Nahla for talking about the practice of the CEDAW committee, and Judge Ntaba for talking about the considerations for judicial officers, many of which I could identify with. I would have wanted to make some general comments first on access to justice of women, and I'll just maybe focus on the situation in Mauritius, not only because you've asked me to, but also because, as I've said, I wouldn't want to repeat what my co-panelists have said. So I would, to some extent, repeat what Nala said, because wearing my ex-CEDAW committee hat, I would also wish to highlight the excellent general recommendation number 33 on women's access to justice. And as I believe she said, it dates back to 2015. Unfortunately, I don't think, and that is something that we saw as well when we had those constructive dialogue at the time that I was on the committee, that states parties pretty much are not applying, or maybe are not even aware of the recommendations made in that general recommendation. And I wouldn't want to attempt to summarize it within the short time which I have, but of course I strongly commend it to whoever is watching us. It's accessible on the internet, on the CEDAW, HCHR website, and I think they would find that it makes good reading, and although this back to 2015, I think many of the recommendations are yet to be applied in an effective manner. I would only highlight maybe the 6 interrelated and essential components that it sets out as being necessary to ensure access to justice, following from Articles 2 and 15 of the Convention mainly. Justiciability, availability, accessibility, good quality, accountability of justice systems, and provision of remedies for women. The definitions are provided at paragraph 14 of the general recommendation, and then you have the recommendations at paragraph 15. I thought that might be a helpful introduction to the topic of access to justice of women. And also because I'm talking about the African context, maybe to highlight the Maputo Protocol to the African Charter on Human People's Rights on Rights of Women in Africa. Again, Article 3, right to dignity, Article 4, right to life, integrity, and security, and Article 8, in particular, on access to justice and equal protection before the law, and including effective access by women to judicial and legal service, including legal aid, and reform of existing discriminatory laws and practices. And Melissa has already referred to those as barriers among many. So having very briefly set out this broad framework, let me try and look at the situation on the ground, and in particular, as you've asked me to, Kajal, the challenges faced by judges, including Supreme Court justices, when adjudicating cases related to rights to privacy, dignity, equality, and non-discrimination of marginalized women. Now, the problem I had with this question, although I didn't want to ask you to rephrase it, is that judges, by and large in Mauritius, do not face challenges when adjudicating such cases, because there are hardly any such cases that are brought before our courts. And that is a matter for concern. Of course, when we have cases relating to domestic violence, labor issues, family law, we've heard about divorce, we've heard about maintenance, etc. They do raise issues of discrimination, intersectionality, etc. But we don't really have cases framed in terms of breach, violation of rights of women, whether under the Constitution or under the domestic laws. And that is very much a matter for concern. And that applies not only to the courts, but also to other mechanisms that we have, like the Equal Opportunities Commission, National Human Rights Commission, the Ombudsman, the Ombudsperson for Children. And Patricia Schultz is here in the audience, and she might remember when Mauritius was examined in 2018, was examined by the CEDAW committee. She took a very strong, I think you put questions on Articles 1 and 2, if I'm not mistaken. And you took the state party to task about this multiplicity and complexity of institutions. In some countries, you don't have enough mechanisms for redress. In Mauritius, you have too many, and there is overlap and there is complexity. And that is one of the recommendations that was made, that, try and streamline and make it easier for women to access and to be able to vindicate their rights. But as I've said, there's rarely any complaint that is based on discrimination against women per se, or even right to privacy of women, let alone marginalized women, as opposed to men. So if there are complaints of such violation, it would be in a sort of general way, not as affecting women in particular. And even when we talk about CEDAW, Nahala referred early on to the optional protocol, communications being made to the under the optional protocol to CEDAW. Of course, we are all conversant with this complaint mechanism for women in states parties to the optional protocol, complaining of breach of convention. And there's not been one single complaint under the optional protocol to CEDAW that has been made by Mauritius. Certainly when I was on the committee, I don't know whether Nala can inform us whether there has been a complaint during this last year. And sadly, the reason for that is not because there is full substantive equality in Mauritius, that is between men and women. That is unfortunately not the case. The reason might lie more in the lack of visibility and the insufficient reference. Then that can be seen in the insufficient reference to the convention in court judgments and Equal Opportunities Commission decisions. And in fact, again, if I may refer to the concluding observations of the CEDAW committee in 2018, the committee did ask Mauritius to undertake a review of its judicial complaint mechanisms available to women, to simplify procedure and enhance access to justice for women. So that was a problem that was identified by the committee. So yes, certainly lack of awareness, and this again has been highlighted already by my co-panelists, be it on the part of complainants, of the legal advisors, of human rights defenders, the legal profession itself, lack of awareness about remedies both in the domestic system and under regional and international systems. Of course, lots of efforts are made to enhance this awareness, be it at the level of government, but also through NGOs. As a former magistrate whom I know, who's now at the head of an NGO called Empower, and she conducts a lot of sensitization with regard to women's rights. But also at the level of the IJLS, the Institute for Judicial and Legal Studies. And I myself, I conduct an induction course for future law practitioners. And I've introduced a course which it used to be, you know, on constitutional law and on, you know, law, domestic law, but I've introduced a sort of module on the overview of international human rights system. And when the future law practitioners look at me a bit blankly saying, you know, what kind of course is that? And I tell them, well, you might have to advise your clients tomorrow, not only on domestic remedies, but also under the optional protocol to any of those covenants once domestic remedies have been exhausted. Now, also in Mauritius, we like in many of the other countries we've heard about today, we have very dedicated NGOs, be it on gender-based violence, relating to rights of sex workers, disability, abortion, poverty, extreme poverty. And so you would have expected, therefore, that they would have channeled cases of violation to courts or to any of those other mechanisms that we've talked about. Again, I don't quite know how to explain the fact that there are not any, in fact, cases being brought before court. And one of the possible reasons might be that they've assessed that advocacy and action on the ground would be more fruitful than going the legal way. And maybe I'm not well placed to say why that is the case, but maybe that is something that should be taken up at the level of the NGOs themselves and members of the public. And I wonder whether they have, in fact, explored legal avenues, or they are ignorant of legal avenues that are open. It could be a combination of both. It may also be that they prefer to raise matters at the administrative level, and they find that you're more likely to get a remedy than through the court system. As I say, maybe I'm not well placed to give an answer to this question, but that is something that I raise as a possible explanation. I think there is also in Mauritius what I would call a cultural impediment. I'm not a sociologist, obviously, but to understand Mauritian society, you have to look at a sort of a mix of African, Asian, European values, because of course, Mauritius is a multi-ethnic, multi-religious country, history of European colonization, dark days of slavery, people being brought in from Africa, and then indentured labor, and people being brought in from India and the South Asian continent, and then immigrants from mainland China. So all that mix of different values in Mauritius, so we have to bear that in mind as well, and that might result in a particular sort of shyness or coyness regarding sexual issues of privacy, and that might or might not be the reason why all cases that are based on sexual orientation so far, as far as I know and as far as I remember, seem to have been brought by male homosexuals. I've read in the papers that there's possibly a first case based on sex change and the impact that this should have on the civil status in the birth documents. I'm not sure, whether this case has been lodged in court or whether it's being addressed at the administrative level. Of course, this gives me the opportunity to flag a recent judgment of the Supreme Court of Mauritius, which I know some of you might have heard about, the case of ASIC. I know Kajal knows about it, and I hope other panelists and other participants have heard about it. I know Patricia as well knows about it because she wrote to me to congratulate me about this judgment of the Supreme Court. Sadly, I was not on the bench, but I'm very proud of my brother and sister who gave this judgment. I mean, quite obviously, I mean, in a nutshell, for those of you who haven't read the judgment or read about the judgment, it was in BBC, it was everywhere. So that's basically about the criminalization of sodomy between consenting male adults being held to be unconstitutional. And of course, that is an enlightened judgment taking on board not only jurisprudence from other Commonwealth courts, India, South Africa, etc., but also and especially that of the Human Rights Committee and the famous case of Tunen, and repudiating colonial archaic laws that were at one point in force in most Commonwealth jurisdictions. And of course, this case has been brought because of courageous litigants who persevered over several years. And another interesting feature about this case is the substantial support that has been brought from international NGOs, local bar and NGOs, and I suspect maybe even the ICJ. So that allows me to indirectly answer Kajal's question about the pressures and challenges that we would face when adjudicating such cases. I think ASIC is a good example of how the judiciary in Mauritius would address or adjudicate such cases if and when they are brought. And as I've said, there have not been many cases, there have hardly been any cases brought. So ASIC showed that the Supreme Court of Mauritius reacted not in a conservative, over-proceduralistic way, but addressing squarely the issue while taking into account, as I said, the progressive jurisprudence from Commonwealth jurisdictions, which are persuasive authority, but also international human rights law. And I find this very gratifying and encouraging that reference was made to the jurisprudence of the Human Rights Committee. And I'm hopeful that one day, in the same way, the jurisprudence of the CEDAW Committee or the African Commission will be applied in the same constructive manner. This is not to say that with the judiciary in Mauritius doesn't need to be, continually made aware. There doesn't be this effort to have a continuing awareness raising. And of course, I've heard loud and clear what was said about the 8 March principles and the Bangkok General Guidance. I think it was Melissa or Kajal who mentioned it. And of course, these are principles about which there needs to be awareness raising, not only in our Supreme Court, but I suspect in other courts in the African region. And I think we can learn and build on what's been done in the Asia Pacific region, in Asia in particular. I don't think we should reinvent the wheel. We should probably build on what's been done, learn what has been made, and maybe why not hold mixed Africa-Asia workshops, or whether online or in person, and try and benefit from each other's experience. I think maybe I'll stop here, Kajal, on the first question, bearing in mind the difficulty I faced in directly answering your question, because there have not been many cases for us to adjudicate on. So that's why I've used the case of ASIC to try and extrapolate on how the Supreme Court of Mauritius would handle such cases when called upon to adjudicate such issues. Thank you.
Thank you, Aruna. And the second question for you. Given the importance of ensuring access to justice for women, especially survivors of GBV, what legislative and policy changes, legal strategies, digital tools, and judicial practices do you believe are essential to have proven effective in Mauritius? And additionally, how these initiatives can be further enhanced or expanded to address existing barriers and ensure a more inclusive and responsive legal system for women seeking justice.
Thank you, Kajal. And again, I will start with a sort of a disclaimer, and because this is a very vexed political issue in Mauritius right now. The reason being that in recent weeks, we've had a high number of cases of femicide or feminicide. And so therefore the adequacy of the arsenal in our laws, etc., is very, very politically charged. So that is an issue on which I would exercise my judicial restraint and be very careful of not entering the arena. But I can definitely highlight that in Mauritius, since 1997, we've had the Protection from Domestic Violence Act. And of course, it's been amended on a number of occasions, as no doubt has happened in other jurisdictions as well, because this is you have a law and you see that it's not 100% effective and there are gaps to be filled. And so there have been amendments on a number of occasions and it's still under review. But very broadly, what the Protection from Domestic Violence Act provides for protection orders, tenancy orders, occupation orders, and they are issued by what we call district courts on an application of the victim of domestic violence. And one of the complaints that's been made recently, when we had this, interest because of the recent cases, is that apparently no occupation order has been issued by magistrates in the recent year. In terms of facilities that we have, because you've asked me about some of the good practices, of course, in terms of, there are shelters, but not enough. It can certainly be addressed and enhanced. And the ministry also has, I think a few years ago, set up this mobile app so that victims can also make complaints through the mobile app, and that is a mobile application, so that to make it easier for women to access the protection system. And as well, there's awareness raising at different levels conducted by the ministry and by NGOs. The law provides for proceedings to be in camera. So we talked about dignity, etc. earlier. We talked about privacy. As the support and involvement of the Ministry of Gender through enforcement officers. And as I said, this is done in district courts, so it's decentralized, often in the afternoon in chambers with a view to protecting the privacy of the victims. A number of good practices in Mauritius which have inspired other jurisdictions as well. And one of the things that we've heard mentioned, again, I think it was Melissa, if I'm not mistaken, we talked about the need for the judiciary to be representative. In Mauritius, that's another good practice that we have regarding gender representation. And that is that magistrates and Supreme Court judges are mainly women, clear majority of women. For the Supreme Court, 2/3 of the Supreme Court judges are women, 1/3, I think, are men. The Chief Justice is a lady. The Senior Appointed Judge, who's Judge number 2, is a lady. The Chairperson of the Bar Council is a lady. The President of the Law Society is a lady. So in terms of representativeness and inclusiveness, I think we obviously are ticking the right boxes. Of course, I would like to say that the reason why there are so many women in the Supreme Court is that we are better. But what it shows is that there is no structural or other barrier. And some people say it's because it's easier for male lawyers to work at the bar. So that's another debate. We won't go into it. It is good enough that women are so well represented at the Supreme Court and the Bar Council and the Law Society. The reason I've said that as well is that I think I can fairly and objectively say that there is no issue of gender representation or gender stereotypes, even at the level of the male judges, the minority of male judges at the Supreme Court. But then we still have got to ask ourselves, if there's no problem at the level of the court, why then is there still a relatively high number of feminicide cases in such a small country like ours? And I apologize, I have no statistics. I know we're always talking about data collection, but there's a particular sort of, and I'm watching my time, I hope I'm still okay. The feminicide in Mauritius is usually within the home setting. Usually the cases of a long history of abuse, and the cases of abuse are known to neighbors, known to children, known to relatives within the same compound, often alcohol, drug related. In some cases, complaints have been made, but they're later withdrawn, often related to financial insecurity. And I think it's Justice Ntaba who mentioned this as well. And the feeling of shame, people don't go and make complaints because they are ashamed. And lack of support from relatives, including female relatives, including the mother, including the mother-in-law. Why would you go and complain? It's not in your interest, etc., etc. And we even had a recent case of a son who killed his father because he said otherwise the father would have killed his mother. So how do you address this? Some solutions have been already canvassed by my fellow panelists. Same things I think would apply to Mauritius as well. Education of not only women, but also men, education of children, because you think, those children have seen these cases of abuse day in, day out, and they did not, maybe they were not aware, maybe they also felt vulnerable, they didn't go and report them. But also education of senior citizens, because they often have those deeply embedded cultural values that say, oh no, this is the kind of thing you should put up with. You should be strong. You don't just go and terminate your marriage because he slapped you once or whatever. So there's an education, an awareness raising that has got to be done at those levels as well, and maybe creating an obligation for neighbors, staff, doctors to denounce. Of course, shelters, financial support. Rehabilitation of aggressors. I think all these issues have been canvassed. Do I have some more time, Kajal, to just go through one of my recent judgments very briefly?
I'm happy for you to go through to one of your judgments. There's only one question, so I think we can give you a little bit more time.
Thank you very much, Kajal. So with your authorization, I wanted to go through a recent judgment of mine, which is called RVS and VS. And of course, I'm referring to initials here. And that was a two-judge judgment on appeal. I sat with another lady judge, and the judgment was delivered by myself. And we decided to use those initials precisely to preserve the privacy of the parties. That was not asked for by the parties or by the legal advisors. So that's an interesting case, because that's a woman who had applied for an occupation order, but withdrawn her application for a protection order. So by withdrawing her application for a protection order, she was in effect admitting that there was no issue of violence. And so when she went before the district magistrate set aside her application for an occupation order, and she appealed, and this is how the case came before us. And when the case came before us, there were various procedural issues, and the preliminary objection was strictly well taken, procedurally speaking, but we declined to set the case aside at the jurisdictional ground. And we said that excessive insistence on proceduralism does not serve the interest of justice, and a fortiori, Latin expression like judges like them, that would apply in relation to applications under the Protection from Domestic Violence Act, where the right to access to justice of presumed victims of domestic violence should, as far as possible, not be denied solely on procedural grounds. So we did not set aside the case on procedural grounds, went on to consider the merits of the appeal, though the procedure was flawed. And when we considered the merits, we held that the appeal was utterly unmeritorious and was in fact an abuse and manipulation of the mechanism provided for the protection of genuine victims of domestic violence. So my sister judge and myself, and of course me as a former CEDAW committee member, as I consider myself to be a human rights judge, it was a difficult thing for me to say that this was an abuse, manipulation of the mechanism. But we felt we had to temper what we said by saying that because that particular case was an abuse, that could hinder genuine victims. So in a way, although we set aside the appeal on the merits, we made sure that we said that there should not be such abuse in order that genuine victims might not be penalized just because this case was unmeritorious. By withdrawing her application for protection order, she was in effect admitting that there was not any need for protection as victim of domestic violence. The psychological report had said that there was no issue of violence, and she said that she needed the occupation order because she didn't have enough space at her parents' place. Although there was no risk of violence, there was no longer any, there was no violence on the part of her husband. So she wanted to live in the conjugal home to the exclusion of her husband, although there was no risk of violence. So, as I said, I think we were a gender-aware bench, a gender-sensitive bench, but we did everything to ensure that genuine victims should get redress. But in this particular case, we had to set the case aside. So that was just one case I wanted to highlight, bearing in mind that, of course, we may be criticized for having set aside this appeal, but it was not a genuine case. And allowing not genuine cases to succeed is in effect doing a disservice to genuine victims. So that was the position we had in this case. Thank you very much.
Thank you so much, Aruna. That was really very interesting, and thank you for giving us a snapshot of how things are operating in Mauritius, both within the courts and within the human rights environment. We really, really appreciate that. And there's only one question. I want to say to everybody who's still in the webinar, if you do have questions, please send them to us. It's probably most useful or quickest for you to write it up into the chat, but if you'd like to raise your hand, that would be okay as well. So there is one question from Carolina, and it's directed to and Melissa, I'll leave it up to you. You can respond, or you can ask me to respond as well. So the question for Melissa is on the Bangkok General Guidance. So Carolina is asking, how was the Bangkok General Guidance received by judicial systems in the Asia, South Asia, Southeast Asia regions, and whether we know that it is already being used by some judiciaries?
Yes. Yes.
Thank you, Kajal, for that question. I think you can answer it in depth, but actually I do have an interesting perspective to share. In my previous role as a member of the UN Working Group on Discrimination Against Women and Girls, last year I led a country mission to the Maldives, and as part of that mission, that country visit, I had the opportunity to meet with Supreme Court judges in the Maldives. And when we conduct those missions, the idea is to identify how discrimination against women in law and practice is being addressed, and with the idea of also understanding the context and making recommendations for reform. And the Supreme Court judges actually talked about, that was the first time I heard about the Bangkok guidance, and they presented that as an example of how they were trying to make their work more gender sensitive, more responsive, And they actually spoke very proudly and very excitedly about how they had embraced the guidance and what they plan to do with it. I believe Justice Shujun was also involved in the process of adapting the 2016 guidelines and updating them and putting them in the context of South Asia. So yeah, actually, I do have that one example, very impressive example. But Kajal, you may have more. So back to you.
Thank you, Melissa. I'm delighted to hear about your experience in the Maldives on the Bangkok General Guidance. I've been to the Maldives a few times, met with the Supreme Court justices, so I am absolutely delighted that they've taken it on board. And then to respond to Carolina's questions on the Bangkok General Guidance, so the first country to formally adopt the Bangkok General Guidance was Indonesia, and this was many years ago already. And they've adopted it. They're using it in their judicial training. It's part of their court system, and it's a very good experience and a good learning experience for other judiciaries to look at the Indonesian example when they are looking to adopt or formally use the Bangkok General Guidance in their day-to-day work. There are 6 judiciaries who have adopted the Bangkok General Guidance. Maldives is one of those judiciaries. The other ones are Pakistan, India, Nepal, Sri Lanka, and of course, Indonesia. And they've done so in a number of different ways. Some have formally adopted, some are unable to formally adopt because the process to be able to change their laws is too complicated. So what they have agreed to do is to use the guidance immediately and to use it in their training programs and by their judicial training institutes, so they can immediately roll this out in their training, and judges can already start referring to it and using it as part of their day-to-day guidance in both their courtrooms and how they operate generally within their judiciaries. There was something else I wanted to say, and now I don't remember it. I'm going to go back to the question. Oh, yes. It has also been referred to in a court case, which we are also delighted about. So it's in an Indian court case. India was not a focus country of ICJ's Women's Access to Justice program. We did include Indian judges in our regional judicial colloquiums, but they were not a focus country. So we didn't actually travel to India and do training with judges. But despite this, the champions that we'd selected from India were so excited about the guidance that they took it back and shared it with all of their judges and their judicial training institutions. So they've adopted it in their training processes. And it was formally referred to and used already in an Indian case. It was the Aparnabad case, which I'm sure if you Google it, it's easily found. But so there's already very good uptake of the Bangkok General Guidance in a number of South and South Asian countries, including by reference in court cases. Melissa, I don't know if there's any other questions. I don't see. Patricia Schultz has a remark. Patricia, do you want to just unmute and speak to that?
Yes, thank you. I wanted to comment on the remark that Aruna made on the lack of cases in Mauritius, and I come from Switzerland, and I can say that there are also not many cases. There are few cases, and I heard of a really interesting counterexample, which is that of Canada. At the time that there was the discussion on the adoption of a new Bill of Rights, women's organizations got together and thought it over and decided that the best thing would be to have a fund. So they requested money from the government, and the money gave quite a hefty sum. And they also requested money from private donors, with which they then supported cases that had a chance of winning. So of course, this is a narrowing of the possibilities for women to access justice, but they thought, we don't have much money. And we want cases that will move forward, that will bring the jurisprudence on this new Bill of Rights in a direction that is positive. They didn't want failures. So they supported cases already in the first instances appeal and up to the Supreme Court on constitutional issues of discrimination, basically. So I have never forgotten this example. And I don't know of other countries where there would exist such a amazing funding system and also identification of cases that would have a chance.
Kajal, if I'm really sorry to intervene like this because I lost my camera and I lost the ability to raise my hand or ask for the floor. And I feel so frustrated.
No problem, Nala. No problem. Please go ahead.
The mic. So I just wanted to add on the issue of the program in Asia and Southeast Asia that I have been privileged to be also to participate in few of your seminars there. And I think what really strikes me is it's true that the formal process for adopting is not maybe at the speed we would like it to see it for various reasons for different countries. But and I want to quote in particular the Philippines, and I'm happy that Colleen is with us to say how much the Philippines has done around that to make things happen, to make things change. I mean, I cannot forget the whole issue of the training they did in regions, the court etiquette, the issues that we don't even pay attention to, like body language, enabling women to speak, welcoming ambiance in the court. I mean, they're doing so much, and the level of engagement of the judiciary and including the Supreme Court and women in the judiciary in the Philippines is amazing. And we saw the difference this time because we had the Philippines for dialogue in October. We could see the difference during the dialogue for a country that has, catered for these issues, that is at least grappling with it, that has committed to do something about it, vis-a-vis country that, are still far away from the process. So I'd like to look at the process not only of the issue of adoption, because I know that Indonesia adopted, but maybe sometimes I think that Philippines is more advanced than Indonesia. So adoption in itself should not be only our aim. Populating them, making them known, vulgarizing them, etc., and reaching out to all parts of the country, because this is where you effect change in individual. And we heard that again from Aruna now and from Judge Ziona, how much the individual judge makes a difference, how much he is equipped or not equipped. So I think we have to continue without having as a sole objective the adoption itself. And then also do as we have promised ourselves when we were last time in the Maldives in the sub-regional, to do an assessment of the implementation, what works, what doesn't work, and what are the new things, because this is a very sort of lively tool, and we want it to remain very much alive. Thank you.
Thanks, Nala. Please go ahead, Melissa.
Thank you, Kajal. I know we're way over time, but this discussion so interesting. I just wanted to add one point about litigation and the volume of cases and how oftentimes there are so few cases. I think it's important to also think about strategic litigation or public interest litigation. So there are obviously these individual cases, and we want to see more women accessing justice and the courts to have more opportunities to respond. But sometimes it just takes one public interest case or strategic litigation case to really set an amazing precedent and then open the door to so many different types of structural changes, even, to shift the public discourse, to also make women feel empowered to actually use the legal system. So it could be, I think, useful for us to also think about ways in which we can still encourage that kind of litigation. I mean, Nepal comes to mind. A lot of groundwork was laid for the Lakshmi Dikta case on abortion, the case that, and Justice Kalyan Shrestha, who's actually a commissioner at the ICJ, decided that case, but that paved the way for so many other cases. And then I just want to mention the Philippines quickly, because in the Philippines, there was this other case that was filed against an executive order that effectively banned access to modern contraceptives. And while that case was not successful in court in terms of, you know, a legal victory, it lasted for about 2 to 3 years and went from one court to the other. But during that process, the way in which the petitioners became so empowered as advocates to speak on the issues and to advocate for themselves, they engaged with the National Human Rights Commission, so many different entities within the system, and the advocacy that accompanied the litigation helped transform a lot of things. So I just wanted to add those dimensions as we're thinking about cases and, you know, some of the things that we can achieve through cases being brought through the legal system. Thank you. Back to you.
Thank you, Melissa. Thank you. Zione, you have your hand up.
I just wanted to highlight two things. I think a lot of us who work in the system, especially judicial officers, I think there's a big aspect that knowledge of making sure people know the law. I think one aspect that keeps coming up is judges keep saying, "Oh, we're independent and impartial, and as such, we can't do the civic education." But I think legal empowerment comes from one fundamental issue. I belong to Women Judges Association, and we have one motto: bringing the courts closer to the people, which means the people will only know the courts if they know that the judicial officers are present and available, and as such are able to come to the system. And they will be able to understand what the system looks like. And that can only be explained from judges themselves who sit in cases, and magistrates as well. And there's nothing that judges and magistrates or judicial officers cannot do by actually just informing people what the law is and where they can go in terms of spaces that they need to get redress. Finally, in terms of cases itself, sometimes I think fundamentally we also forget as judicial officers that we have immense powers to actually call for cases to come. One of the things that we have as a power as the High Court, I know in Malawi, is that I can see a case in the newspaper and still be able to say, can this come before a court? Can this be prosecuted? Can this come for review? And that is something that's significant. And I think if judicial officers use their powers that they have responsibly to ensure that they address the human rights violations that don't necessarily just come into the court, but they see from their day-to-day use of social media, the paper or radio, whichever way comes to them. Or even sometimes they come to us in our private homes. Somebody says, such and such happened to this person. What is the process? That also very much is a significant way of raising the awareness, but also making sure that the cases are brought before us. And lastly, the use of the judge's work itself. Sometimes, as I said, a case can be a marital case, but you realize in that case there's been defilement cases, sexual offenses cases, there's been abuse. There's no reason why you cannot refer the criminal aspect to the necessary parties, and you continue dealing with the civil case that was before you. So I think there is a lot more that we can do as judicial officers, but also anyone working within the judicial space and the legal space to bring into focus these cases for us to actually have better protection and promotion of human rights for women out there, especially against gender-based violence. Thank you.
Thank you very much for all of those comments, the questions, in particular for the 4 presentations from Melissa Preti, Nala Haider, Aruna Narayan, and Zione Ntaba. They were rich, informative, showed a wealth of expertise in this area, and so we are very grateful for these presentations and for giving us your time, and quite a long stretch of time as well. We're greatly appreciative. I also want to say thank you to Mulesa Lumina and to Jonas Sindani in the Africa team, and to Kalino Bias in the Asia team, who worked behind the scenes to put this webinar together, and then to all the participants who attended and listened very attentively. Thank you so much for joining us. Just want to say that the webinar has been recorded. It will be placed on ICJ Africa's Facebook page, possibly on the Asia page as well. Yes, Melissa is saying yes, so on both the pages. So you can access this going forward and share it with anybody who you think might be interested. I want to thank you all, and I wish you well. Thank you so much. Goodbye.
Thank you
Goodbye.
very much.
Bye.
Bye, friends. Goodbye.